Good evening, everybody. Welcome to the June 29th meeting of the Albany County Legislature's Law Committee. Hope you're all having a nice evening. Deputy Majority Counsel, would you wish to call the roll, please, if you could?
Sure thing, Madam Chair. Ms. Plotsky.
Thank you. Present.
Ms. Cunningham. Mr. Bergdorf.
Present.
Mr. Feeney. Mr. Kuhn.
Here.
Mr. Peter.
Here.
Mr. Ricard.
Present, Mr. Deputy Majority Counsel.
Ms. Whalen.
Yes, hello, I'm here.
And Mr. Mayo.
Here.
7 present, Madam Chair. You're muted, Madam Chair.
Sorry, thank you. All right. Have people had a chance to review the minutes from the last meeting?
Madam Chair, I have, and I'd love to make a motion for that if so acceptable.
Thank you, Mr. Peters. Is there a second?
Second.
Thank you, Mr. Ricard. All in favor?
Aye.
Aye.
Great. Passes unanimously. Any opposed? No, great. Thank you. Passes unanimously. Let's go right to item number 2. This is local law A for the Tourism Improvement District in Albany County. This is being tabled at the request of sponsor. Local law 3, number 3, local law L for providing counsel during eviction proceedings. This is also being tabled at request of sponsor. Item 4, public hearing on local law B. This is Ms. McLean's bill concerning, exempting the county from wireless communication surcharges. This is also being tabled at request of sponsor while she gathers a little more information. Item 5, local law C. Public hearing for local law C is being tabled at request of sponsor because the sponsor, Mickey Cleary, is not able to attend this evening. Item 6, let's come back to this. Is Carolyn McLaughlin on? I do not see her.
She's not on, and we haven't been able to get a hold of her, but I, as you were about to do, I would suggest just moving on, and if she appears, you can go back.
Yeah, okay, we'll circle back to that. Number 7, local law B, table at request of sponsor. Number 8, local law C, also on the catalytic converters, tabled at request of sponsor. Number 9 is local law E, tabled pending a public hearing. Sorry, we're going to wait. Sorry, we're holding on that as well. This is also for Carolyn McLaughlin. We'll see if she is able to attend. And this brings us to number 10, public hearing on local law F regarding requiring all weapon and firearm dealers to post disclosures regarding safety risks from firearms. And Legislator Reedy is here this evening. Would you like to speak about this, Mr. Reedy?
Sure. Thanks. Thank you, Chairwoman Plotsky, and good evening, everyone. So I believe we're voting to pass this on to a public hearing. And again, I think this is a fairly straightforward and simple piece of legislation requiring both a warning sign and contact numbers for emergency health services and the National Suicide Prevention Line to be displayed anywhere where firearms are sold, and also given out when folks obtain, firearm permits and registrations. And there is an update on local law F. Will also require the warning to be given out to individuals when they do purchase firearms. There's a couple changes in the language from the bill's introduction last week. I don't know if I should go over them or if you want to go over them, Brandon. There's just some, I think, a couple edits to make the language clearer and conform to, I think, the definitions in the state law. But beyond that, happy to take any questions. And I do want to thank everyone who signed on to be a co-sponsor on this bill.
Madam Chairwoman, question, it's Jennifer Whalen.
Yes, go ahead, Ms. Whalen.
Mr. How does this impact private sales of, say, like antique guns or rifles or shotguns?
I believe this, well, that's an interesting question. Yeah, I believe this covers any place where a firearm is sold. I want to check into, because I'm not honestly sure how private sales of firearms happen in New York State. I think this would cover any losing my words here, any like firearm, like gun events where they're sold in Albany County. I'll have to check on private sales between individuals of firearms, and I'm not sure what the stipulations are in the state law on that. So I'll have to look into that, Jen.
Okay, what about, say you're left a gun in an estate, or there's guns in someone's estate when they die? What does it is that would the executors have any obligation to provide the beneficiaries with such a statement, or is that something that does it only apply to business operators? I read the legislation, and I've read up on a lot of the new legislation in the state, but I just wasn't sure if it was addressed anywhere with respect to
I know
private
this
sales.
law covers firearm dealers, so I believe this is covering businesses, corporations. I will look into whether or how this would address guns being sold as part of an estate sale. I'll look into that and get back to you on
Or
that.
when you go to like an old gun auction, like the auctioneers have guns, they have to post this sign also in their auction houses.
I will check on that. I would think so, although I will be honest, I have never been to a gun auction before, and so that concept is a little new to me. But I'll look into that.
Thank you. Thank
Well,
you.
we can, listen, we're the law committee. We can figure this out. I think you look at the text of this thing and answer all these questions.
It does say firearms do not include an antique and inoperable firearm. So if it's operable, assuming this would apply, and a dealer seems to be defined as someone who engages in the business of. So I don't know if that would include a casual sale of a firearm from one individual to another, but I think those would be matters. We can discuss this a little more. I think those would be kind of, if someone were to get cited under this law, then they could argue that the legislation did not apply to them, to whomever would be reviewing their objections. Just a couple quick thoughts from looking at the language here.
Right. Well,
Mr. Kuhn?
I'm sorry. Yeah,
No,
well,
Mr. Kuhn, please go ahead.
the teeth of this thing says there's a disclosure notice that has to be posted at the site where such weapons or firearms are displayed or delivered to the purchaser. So it certainly doesn't seem to contemplate private sales, right? You could look at the language of this thing and say it's not contemplating one-off private sales. So I don't think we need to worry about that. It certainly doesn't contemplate the robust passing down of firearms through estates. I don't think we need to worry about that either. It talks about the business of selling firearms. So to Ms. Whalen's concerns, I don't think it applies to one-off sales, and nor do I think it applies by the plain language of the statute to guns passed down and from an estate to somebody.
Mr. Peter?
I believe Mr. Bergdorf was before me, and I'll wait till he goes, but so.
I'm sorry, Paul. I did not notice that you had your hand raised.
No, I had a question similar to Jennifer's. It is not unusual for people who own firearms And by the way, there are 40,000 pistol permits in Albany County, at least 40,000, and maybe as many as 50,000. And that does not include long guns. So my guess is there are probably a couple of 100,000 guns in Albany County that are legally owned. And I wanted to be very certain that this does only apply to gun stores or people who are in the retail sale, because it is not unusual for someone, a father, to hand down to his daughter a Ruger 22 semi-automatic 22 plinking rifle. And I would hope that would not require notice. And I hope what Jeff said is clear, but I think you ought to make it very clear that it only applies to gun shops if that is your intent, and not to create a giant umbrella and people and a host of unintended consequences.
Thank you all.
Okay, Mr. Peter?
Sure, I would just like to say I understand the concern and all that. I would say that I tend to agree with my colleague, Mr. Kuhn, as well as what Mr. Reedy is trying to do. I would say we should move this for public hearing with the caveat that intent is just, that caveat is just further explained. Although I do believe, to Mr. Kuhn's point, I think Mr. Reedy's point, it specifically talks about a dealer, and a dealer is a specific type of licensure, right? Like there's a difference between a car dealer and someone who is selling a car from person to person. There's a difference between a realtor and a private sale, like in housing, so we have to at least allow us to have a little common sense on that one. But I would think that we can move this to public hearing with just a specific thing that meets Mr. Bergdorf and Ms. Whalen's points, because I don't think it's supposed to deal with inheritance or a person-to-person sale, but specifically a dealer. And I think we can easily come up with what the definition of a dealer is to give everyone comfort. Because I think besides that, this is a very common sense law that can easily be convoluted, but I think is really clear in its intent once we just define what a dealer is.
Oh, there is we could tweak the definition, but there is a definition in here, and it already seems to say who engages in the business of.
Right.
So I that's not an estate, that's not a gift from a, father to daughter.
It's not inheritance, to your point.
Not inheritance.
Madam Chair,
I would think it would apply to an auction. So-
hello.
Yes, Ms. Whalen.
I'm sorry. So when you're an auctioneer, you get estates and you might get an old car to sell, but it doesn't mean you're a car dealer. You might get some old guns to sell, but it doesn't mean you're a gun dealer. So I think that you do really need to consider all of these little carved out situations, because it isn't that clear.
Mhm.
Like I wouldn't say that an auctioneer selling used furniture is Stickley Furniture Company. They're not furniture dealers. So I am, I think that the definitions certainly need to be tightened up. And then again, I did read it, but I was wondering, will there be a form as part of the legislation that these folks can easily just print out and put on their bulletin board? Or, is there a standard form incorporated into this with the language? Kind of like, it reminds me a little like, like as attorneys, a while ago, 20 years ago, we started to have to post like clients' bills of rights in our offices. So this has language that's specifically spelled out that you can just print it out and, laminate it, stick it on your door type of thing, correct? Is that in the legislation? I'm not sure.
I
The
believe
language is
section
specified in the
4,
legislation.
Part A and B have that.
Okay.
Mr. Ricard?
Thank you, Madam Chairwoman. Just a quick question. Maybe the deputy majority counsel can answer. So if we did what Mr. Peters suggested, send the measure to the floor, can we change the language after the fact to address the concerns of my fellow
Sorry.
legislators, or what?
Just to confirm, Bill, this is only for the public hearing.
That's what I'm saying, but can we change the language after the fact is my question. If, because you're gonna
If
send
we
it to the,
change-
well,
if
you're gonna
my
send it right now
understanding-
as written, correct? As written. But then somebody mentioned that, well, we might want to change the language. So do we need a separate public hearing after we change the language? I guess that's
Yeah.
the question.
A second public hearing would only be necessary if the changes were substantial. The discussions that we've been having on this, in the committee don't seem to reach that standard. Also, between now and the committee meeting, we'll be able to have more research and see what amendments, if any, are necessary to meet the definitional questions that you guys have.
Okay, that's all I wanted. Just a clarification. Thank you, Madam Chair.
Madam Chair,
Mr. Coon? No, Mr. Coon first. Mr.
I'm
Coon?
sorry.
Yeah, this question of the definitions, the definition of dealer in section 3 of the legislation incorporates, it's got a bunch of terms in it, and it incorporates the definitions in section 265 in the New York State Penal Law. Well, 265N of the penal law defines a dealer in firearms. Frankly, if I don't really see the need to do anything else here, right? It's a state statutory term. It's defined. That's enough clarity.
That's a good point, Mr. Coon. Thank you. I have the penal law here somewhere too.
And there's also, if you really want to add to it, you need a license in this state to sell firearms. So if you wanted to, you could say this includes, a dealer includes anybody who needs to get a license as a dealer under state law. That way it would eliminate the potential to, if it's sort of this one-off sale, private sale, if that doesn't satisfy the definition of a dealer under the state law, it wouldn't activate the requirements under our local law. And it also would make it clear to the concern about the passing along of weapon. Obviously, that wouldn't be a concern either. So honestly, I think the way this is written is fine.
I agree. I'm reading the definition of dealer in firearms in the penal law, and it does track this. And if we were to tweak our definition, then there'd be conflicting definitions in the two different laws, and that could cause confusion. So I think going with as this is drafted is the right step at this point. And again, this is just going for the public hearing. So, Mr. Bergdorf.
just for the committee's information, I talked to Bruce Hidley today, and as you know, with the recent court case, the Office of Court Administration has not yet decided how they are going to deal with currently issued restricted permits, whether people are going to have to go through the permit process again, or whether the restrictions are just null or void, or whether Mr. Hidley's going to have to issue new permits. So they are waiting for the Office of Court Administration to give them direction. Also, Mr. Hidley was not aware of this law, so you might want to, the sponsors might want to reach out to him, and because you give him substantial responsibility, both for handguns and for rifles. And there was also a special session that was called by the legislature, which is supposed to come in, I think, tomorrow, for more legislation, so that there is going to be a changing landscape ahead of us in the next 30 days. I'm willing to vote for this to go to public hearing, but I just want people to be aware that there are potential changes across this whole subject in the next 30 days or so. 30 days for the legislature, and who knows when for the Office of Court Administration to figure out how they're going to deal with the, million licenses that are out there.
Yeah, point heard. Understood. Mr. Peter.
All that said, and with all the insanity that the Supreme Court is consistently sending to localities in our state. A public hearing, to Mr. Bergdorf's point, it doesn't harm anyone. So I think with all of that said, and with all the clarifications specifically around the penal code as exists right now, and if we have to change it, we have to change it, much like the Supreme Court amending many a thing, I would make a motion to move this despite what might change from those 9 justices.
Is there a second?
Second.
Thank you, Mr. Ricard. All in favor of this going to public hearing?
Aye.
Aye. Any opposed at this time? No, thank you all. Passes unanimously. Thank you for the discussion.
Hey, thanks for your time, everyone. Pleasure to be with you, and we'll talk to you soon.
Take care, Dustin. Thank you. Item 11. This is the public hearing for local law G concerning remote video conferencing. Chairman Joyce is with us this evening to talk about this. Am I correct?
I am here. Good evening.
Good evening. How are
Yes,
you?
this is the public hearing for the remote option we were provided from the state of New York. I'll just say that the provisions provided in the remote option that the state crafted aren't really applicable to our process here in the legislature. I hope the discussion will progress and over the next couple of weeks and months, provided given this option for the ledge, but through our discussions with staff and in our rules reform and legislative modernization committee, we're adopting this remote option into our rules, so we have it. But I don't believe the provisions provided in the state law are really applicable for what we do in the legislature. But it gives us the foothold that we need to provide for the option going forward if we can change it to our process, but adopt it nonetheless and go forward.
Okay. Are there any questions for Chairman Joyce?
Yeah. Go ahead, Paul.
Andrew, I when we got the memo from your office about the status of meetings for June and July, I was actually surprised to see that July was going to be a remote meeting. Is that under the governor's state of emergency or the county executive state of emergency, or what is under what authority are we operating now, and when is the end date?
Under the governor's authority right now. And after the month of July, we can't really predict what they're going to do, but I would, if I were to guess, I would say the mandate would, or the authority to be remote would end after July under the governor's executive order. And then we'd have to reassess what we do going forward.
Okay, thank you.
Yep.
My question is, this definition of extraordinary circumstances, I'm not sure why we're including this last sentence. This term shall not include pre-planned events which are not medical in nature or employment or professional responsibilities. If somebody is, I don't know, and we talked about this in the other committee. If someone, I don't know why we're drawing this so narrowly. Like if somebody go ahead.
Yeah, it's not us. This is the state language, and again, I don't imagine that we're going to change our process or our procedures for attendance. Either way, it's just too onerous of a process to employ for us. If somebody has a work requirement, or as it's defined as an extraordinary circumstance, they're just not going to be at the meeting. We're not going to provide a vehicle for someone to try to be remote, per those definitions. But this is what we were given, and this is what we're going to adopt, and with the hope of improving and continuing the discussion going forward.
So Andrew, are you seeing this as kind of a take it or leave it?
Exactly.
According to who?
Like, is this based on the state statute that
Yes.
we have to track that same language, or do we have any, flexibility there at all?
Madam Chairwoman, if you just look at the entirety of the state law, it pretty much reads like they want you in person. They want the meetings back in person and they don't, I mean, does it provide a remote option? Yes, or a hybrid, I guess I'd call it. But it has the requirement of a quorum in person. It tracks more like the old law than it does that which we are operating under right now. So if it were in person, you would have to be in the county. The municipality has to conduct its municipal business within the municipality. That's the standard rule. So you should be in the county when this is occurring. We just analogized a different portion of state law. But the tenor of the entire state law says that these meetings should be occurring in person. So we're going to have somewhat strict rules in order to comply with the general tenor of the state law.
Right, but Pat, this last sentence here, this term shall not include pre-planned events which are not medical in nature or employment or professional responsibilities. Is this entire definition of extraordinary circumstances somehow mandatory under the state law?
Not explicitly, but a pre-planned non-medical event is like, if I had to go, I went to my son's graduation last week and I took off work. You got to just take off work. That wasn't an extraordinary circumstance. I just took off work.
Right, but the modifier is, well, first of all, extraordinary just means out of the ordinary, right? And significant or unexpected, right? Well, significant and unexpected mean two different things. I guess I'm just not clear if everybody's there and we have a quorum, but we got 3 members who we have quorum in person, and we got 3 members who have professional obligations that require them to not be there. What's the harm, and why wouldn't we want those 3 members to be able to participate in the meeting? Now, we're not talking about somebody who's missing meetings all the time, but occasionally people have professional commitments that require them to not make the meeting. Why wouldn't we want to do everything we can to ensure that those members who have some sort of professional commitment can participate in the meeting?
I would like for a full hybrid or remote meeting to get the most robust discussion. I just don't think this law provides, the state law provides it. It is more like the pre-COVID state public officers law than it is what we operated under COVID.
Understood. But let's just, so everybody's clear, what this basically says is that you have to go back in person, right? But and correct me if anything I say is wrong, if we have a in-person quorum, right? There's 30 people at the meeting in person, 35 people at the meeting in person, but 3 people are out because of an extraordinary circumstance. Okay, whatever that might be. Those 3 people are allowed to participate in the meeting remotely if there's an in-person quorum and the reason that those people aren't there satisfies the definition of an extraordinary circumstance.
And they have to be in Albany County.
Yeah, can I ask a clarification on that too?
That's a different provision.
Sure.
Yeah, no, wait a minute. I don't think that's right. I don't think they have to be in Albany County, do they?
This is written to require that, much in the same way that the pre-COVID laws required the official business of the county to be conducted within the county.
Well, being conducted it changes now that we have remote appearances. I mean, we're all conducting business right now, and I'm in Clarksville, but I could be in, Boca, and I'm here. So if we have business down in New York City that we have to travel for work, why would we want to exclude people in the evening when they could attend by phone, by video? I do appreciate Jeff's comment that how does this make sense, and if there's any flexibility there.
I see Lynn's point though about being present in Albany County, although again, why do that?
Just a point of clarification on that, Pat. Okay. Elder care, as an example, would be an emergency elder care situation. That's covered, right?
Oh, sorry. I thought you meant the elder care committee.
Yeah, I'm saying an elder care situation, you've got a relative that you have, and it's not a frequent basis, just an emergency elder care situation. You can still attend that meeting, right? But I'm going to ask a follow-up question after you answer.
Well, this contemplates that situation, yes.
Okay, So now here's where the stickler is. Let's say the individual lives in Schenectady County and you're at that individual's house. So can we participate in this meeting or not?
As this is written, it requires participation, even remote, to occur from within the county.
But that makes absolutely no sense in modern technology where we're at now. That's ridiculous.
I don't believe that's the right interpretation. I think if you're there by Zoom, and the Zoom is produced in Albany County, I think
Which it is.
participating in Albany County.
That's a great point.
Yeah.
That's an excellent point.
No. So it says said member is physically present within County of Albany. The way this is written, if you're taking advantage of this because of the elder care thing or whatever the extraordinary circumstance, you can only take advantage of it and participate via video conference if you are physically present in Albany County. And to Bill's point, why? What is that requirement serving? What possible purpose? If you're not there, you're not there. It doesn't matter if you're across the border in Troy versus you're in, who cares where you are, right? If you can participate, it doesn't make any difference where you are if you're participating via video conference.
Well, I have a slightly different view of this, Jeff. I personally wanted to make sure that people weren't going to Florida for 4 months and saying, gee, my wife has trouble grocery shopping, so I have to go down and be her caretaker. So I have to participate from Florida for 4 or 5 months a year. I don't think that is the sort of thing that our constituents expect of us. I think they expect us to be here. So I am very comfortable with the way the chairman has it drafted right now. It used to be pre-COVID, if you weren't there, you were marked absent. Somebody might say you were excused, but you didn't get to vote on anything. You didn't get to participate. This goes part of the way. It allows for Zoom under extraordinary circumstances. But people are going to come up with all sorts of, I went on a job interview to San Francisco and I spent 10 days doing a job search there. I don't think that is what we should be accommodating by virtue of our Zoom rules. So I kind of like them structured the way they are now, where the Zoom is sort of a little bit of a safety valve, even though I wish we didn't have to come in for every public hearing. I wish that, some of the committee meetings that have 1 or 2 things on an agenda could be done by Zoom, but I guess they can't. So I think what's drafted now is, it's a balance. And,
Right.
You try, you see how it works. And if it gets changed later, it gets changed later.
And again, to my
Thank you.
original
Well,
point, it's not really.
Well, hold on.
We have some hands raised too here. Let's give Joanne a chance here. She has her hand raised, and then Lynn.
Thanks. I'm glad you brought this up, Jeff. I think it's extraordinarily limiting the way it's written. When I saw section 4, and you have to be in the county of Albany, just for my own circumstance, in the year 2020, I had the elder care issue, and my dad lived in Oneida County. And because it was COVID, you participated from anywhere, absent a public health emergency. If that situation happened under this policy, and it was my, turn to help my dad, I can't tell you how many calls I took from his porch room. So I do think the elder care part is limiting, but it's all centered around the Albany County limitation. And for me personally, I had 3 surgeries in 21. Over the past year, I've had 3 surgeries at Johns Hopkins in Baltimore. Many of you might not have even realized I was gone because while I had those surgeries, in many cases, in most cases, I had to stay around Hopkins for a couple of weeks while I recovered. I did the calls, committee calls, while I was recovering. If I didn't have that flexibility, I would have missed a lot of meetings. I also, because I've had 3 surgeries, I've had a hell of a lot of doctor's appointments also in Baltimore that have required me to travel. I've had, in the past 3 months, I think I've had 8 appointments at Hopkins, and they happen to be on Wednesdays usually, which I would miss my committee meetings if I wasn't able to participate remotely. I just think this is entirely limiting in a way where it doesn't have to be, and it doesn't recognize that things happen in people's lives and we're going to have to accommodate them. And I also think Jeff's comment about professional responsibilities, I think there's a way to carve this where it won't be abused and maybe allows for some chairs oversight or something. So if somebody isn't going to Florida for 4 months and saying, hey, it doesn't matter if I'm there or not, but I think we have to have more flexibility, or, we're missing the boat on trying to accommodate real life stuff that happens to people. And it might happen to one of you, and you're going to have to be out of town for a lot of the time. In an entire year, I would have missed a lot of meetings in the past year had not it been for the flexibility of the remote option. I now have COVID, so I'd miss the meetings now, although I'm in Albany County, but I just think some of this is very limiting and it shouldn't be.
Thank you, Ms. Cunningham. Ms. Lukakis.
Akis. I'm
Akis, sorry.
also speaking to you with COVID from Albany County. I just wanted to say that, we've had this conversation in the rules reform and modernization meeting about 100 times. And, if we could get around it, we would. I think it's parochial. I think we shouldn't have to legislate for the lowest common denominator. And it is quite clear that going to Florida is a personal choice, and going to do something professional is not always a personal choice. And yeah, my 25 living relatives, one of them lives in Albany County. So when it comes to my turn, I'm going to have to leave the county to help them. So I don't really know what to say beyond that. If we can do something, we're to talk in the next meeting, which we're late for now, about maybe we can do something to contact the state legislators to see if this can be changed to be a little less parochial. We can maybe write some letters or do some kind of a full court press. But for the time being, I've been delighted to hear what you've had to say, and I also don't agree with it, but I think we're going to have to move it forward because we have to. It's a yes or no thing. It's a take it or leave it, and if we leave it, then we just have to start all over. And no, I don't think any of us are happy about it, except maybe Paul. Sorry, but thanks.
Okay, thank you. So thanks for the reminder that we're running late. Carolyn, quick thoughts from you, if you could, please.
Well, I just wanted to, as I listen to everyone, as a visitor to the committee, it just doesn't encourage people's participation. I mean, I'm in Rensselaer County or I'm in New York County, and I can't participate because I'm not in Albany County. So do I go on or do I not go on Zoom? Or will Zoom even exist for me to be a participant? So to me, it just doesn't encourage participation in circumstances where you find yourself outside of Albany County. And who's going to be the police to say where I am when I sign on for a meeting? Yeah. And there is some accountability and integrity that I carry as a legislator that if I'm not going to be around, somebody's going to know. It won't be just because I'm down the street and I don't want to show up, or, so I don't particularly, I'm not comfortable with it, but as Mr. Bergdorf said, I think if there's an opportunity to amend this going forward, Mr. Chairman, if we can do that, let's keep the conversation going. Thank you so much, Miss Chairman.
You're welcome. Mr. Joyce, last thoughts before we have a motion?
Thank you. No, this is all really, really good input, and I really appreciate the consideration and the points that were raised. Again, to my original point, bringing this up, the state, drafted this without much, insight into how we do things in the county. Going forward with this public hearing in the local law will give us the option to consider and plan for either remote or a hybrid option for the Albany County Legislature going forward. And I can assure folks that we're going to take everything into consideration, given the technology and the left and right limits of the state law and what we do in Albany County, and to make sure that we have max participation, given the left and right limits and the limits in the law. But this is the beginning of the conversation, and these are good points that are being raised, and again, giving us a foothold and an option now for a remote or a hybrid option, and moving forward in a common sense and fair process to make sure we have max participation going forward, given the limits of the law. That's the word going forward, hopefully. Thank you.
Is there a motion?
I'll make the motion.
Thank you, Mr. Bergdorf. Is there a second?
Whalen will second.
Thank you, Ms. Whalen. All in favor of this going to public hearing? Again, this is just for the public hearing.
Aye.
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 Any opposed? Okay, hearing no opposition, then this passes unanimously to go to public hearing. Thank you all again for the discussion.
Thank you.
We're going to go to 12 and 13, then back to Carolyn McLaughlin's bill. So item 12, local law F is tabled pending public hearing. Item 13, local law G is also tabled pending the public hearing. So let's go back to item 6, which is the public hearing for local law E, the Pay Equity Act, and Ms. Carolyn McLaughlin is here to discuss this.
As you all know, I think the underlying, I apologize for not being here when it came up on the agenda.
It's fine. We were going quickly. No problem.
Okay, thank you. But as you know, the goal here is to provide the maximum opportunity for an applicant to receive, compensation that suits their experience, and the opportunity to maximize whatever compensation that is available for a job. It's not meant to be punitive toward any employer who does not include this type of information, so the salary information. But I do believe that we've made some adjustments based on what's taking place in New York City and in other counties. Mr. Collins has been right on top of this. And the latest adjustment was related to the penalty for entities that do not include the salary information. But I think that going forward to a public hearing to carry this forward it's a win-win situation for everyone, I believe. And we want to provide maximum opportunities for people to grow in their work. And if that is not made available through something as simple as this, and being full disclosure on what the salary that a job is going to pay, then I don't know. I mean, we're missing the boat on providing opportunities for people to advance in their careers. So any challenges that other counties have had, I think have been addressed with amendments that we have looked at. So if anybody has any questions, I'm glad that Mr. Collins is here. And I'm fully supportive of this and would ask that you all would give it consideration as it goes forward to a public hearing.
Thank you. Are there questions this evening?
I have one question, Madam Chair.
Yes, Mr. Bergdorf.
I understand that a version of this law passed both houses and is in line to be sent to the governor. Can anybody tell me what, or could somebody lay out for the members of the committee what the differences are between this law and what was passed that is applicable to the rest of the state? because I think, once again, this is not
Right
Albany
here.
County. This is not Albany County we're mandating this upon. We're mandating it many of the people who do business, their people will come from 6 or 7 counties around Albany County. So when somebody advertises a job, do they have to do it differently in Schenectady County or Albany County or Schoharie County or Saratoga County? I thought the whole idea was to have a common denominator that works for everybody. So I once again, I have no problem with this going to local, to public hearing, but I hope we are not creating something that goes beyond the state law.
I'm going to defer to Mr. Collins on that, but I guess I'm trying to understand your question. So if there's a business that is advertising a job, they're in Rensselaer County, but they're advertising in Albany County, are they held to a different guideline? Is that what you're asking?
What I'm saying is, if you're a company that's headquartered in
Mr. Burdorf, I think I can answer this even.
Okay, go
before you
ahead.
get to an example. It requires the job to be performed in Albany County. So if the job's not going to be performed in Albany County, it's not an Albany County job.
People telecommute now. There are all sorts of ways that people work. They work some days in Albany County, some days in Schenectady County, some days in Rensselaer County. So the real question is, what does this law do above and beyond its state complement? And is it worth the unintended consequence? I'm asking a question. I don't know the answer to it.
Well, the state law is not in effect. So this may go in effect ahead of time and help out those employees until the state's law actually goes into effect.
Well, is somebody willing to say that should the state law go into effect, that this law will sunset?
We definitely can look into it and determine that if there's rights being protected or made available to the public that are greater than that the state law offers, I think we should go that route.
I mean, we're at a point in time where every personnel committee meeting, we're giving waivers saying that people don't have to live in Albany County anymore. But
again, we would be an Albany County employer.
Right. But what about the Price Choppers of this world? What about the construction companies that have job sites across 10 counties or across the state?
This is just for public hearing, right? This is not.
No, but there is a state law that is going to the governor, has passed both houses. This is more than a mere hypothetical, it might happen. I'm just asking for someone, whether it's the counsel to the legislature, the county attorney, the majority and minority counsel, to tell us how this differs from the state law and whether or not, so we can make an informed judgment as to whether we want to support.
So that's a legitimate question.
Yeah.
How is this different from the state law?
Yeah, I don't think
we need to know that in order for this to go to public hearing, but sorry, we're terribly late on time. I'm sorry, Patrick, did you want to clarify? And then we have Mr. Green and Mr. Kuhn.
We can absolutely provide those answers. I also just want to quickly touch on the amendments to it. These are all relatively to make sure that the employers aren't suffering from it. It's better defined where the location of the employment has to happen. For first-time offenders, there's a total waiver as long as they correct the problem. It's definitely the amendments are to make sure that employers aren't just horribly burdened by this, but that the law actually affects what it's intended to affect.
Okay. Mr. Graham.
Yeah, I have some questions about this. And I would also be interested to know what the scope of the state law is and whether or not we are just basically doing the same thing that the state law is, or if we're actually sort of somehow beyond the scope of what the state law is. But just the language, advertise a job, promotion, or transfer opportunity without stating the minimum and maximum salary or hourly wage for such position in such advertisement. Well, typically one doesn't advertise for promotions and transfer opportunities. Those are internal within an organization, right? So are we saying, so right, I just don't even understand precisely what the scope of this is. If I've got a business and I've got 200 employees and I've got a position within it that I'm looking to hire from within. I've got an opening and I want to hire from within. And so I post to the organization, hey, everybody, we need a new manager. Tell me, if you're interested, put in an application. Okay, is that an advertisement? And if it is, if I'm send out an email to everybody within the organization and say, hey, we need a new manager, apply if you're interested in this. If that's a promotion or a transfer opportunity, does that mean that that email needs to disclose the salary? I don't think I'm being picayune about this. I really don't understand, I don't understand how this applies to promotions and transfer opportunities.
If you're advertising the promotion or transfer, you got to disclose the salary. If you're not advertising it, you don't have to.
But what does that mean, advertising a promotion or a transfer opportunity? A promotion or a transfer opportunity is typically internal. Are you talking about an internal advertisement?
But don't you still, even in that instance, you still have to put out an announcement that there is a promotion opportunity or a transfer opportunity with all of the details pertaining to the position. So from my interpretation, and I'm not a lawyer and I don't play one, but if I were an employee seeking, I would not want to know all the details. I would want to know all the details. And I'm interpreting this to say that provide me with all the details as a internal employee. I have the same right to have all of the information as I consider applying for an internal promotion or transfer. If that's what it's inferring, I don't know, but I would expect that.
Yeah, well, in all events, I just think there's the policy question of it, which we can discuss, and I think is worth a robust discussion. And then there's just the converting whatever our policy objective is into statutory language. And I don't think this is 100% clear on what the employer's obligations would be in a situation that's going to come up a lot, which is internal promotions and transfers.
Yeah, that's a good point.
Yes, I just want to confirm something. If an employer says, we could use an extra hand here at work, I'm not really sure what we want to pay in salary because we have to know what's available in the workforce now, especially now where it's really hard to get workers. So I want to do what I've always done, enlist it as salary negotiable. That's going to be in my posting. Are we saying New York State and Albany County are saying a business owner cannot do that?
We're asking that business owners offer what they believe to be good faith salary range.
They may not have an idea. They want to see what's out there. Salary negotiable has been around for as long as I can remember. Are we now saying the hand of government can reach into a company and say they can't put salary negotiable in their ad? Because that's what it sounds like.
Ms. McLaughlin, did you?
But even with salary negotiable, there's a range that they have in mind. So, I mean, it could be from 100,000 to 150 or $15 to $20. There's still, you can negotiate within that range. So that's the message.
Okay. Yeah. I think I need to cut this off. I'm sorry.
Chairwoman.
We are 30 minutes over time and I'm going to need to move forward. So my apologies, Ms. Whalen, and to everybody else who has thoughts on this. This is for the public hearing. Is there a motion? Or is this being tabled? What are we doing?
I would
Motion,
thank you, Ms. Cunningham.
Is there a second?
Well, I'll tell you, I'm not going to vote for this. I'm not going to vote to send this to public hearing. There's just too much, right? And we're like cutting off discussion of it because we're an hour over. You know
I
what?
agree.
Maybe we need to talk about this a little bit more.
I'm not voting for it either to go to hearing because I didn't even get a chance to say I agree with my colleague, Mr. Kuhn, and with Mr. Grimm. But there's also some other language in there that's very glaring and
I'm sorry.
basically said,
Really
We got a
sorry.
motion.
We have a motion on the floor. Is there a second?
There's not.
There is not a second at this point. I regret that. I think we could use more clarification. I do support this bill. I am a co-sponsor. I regret that. I think we need a little more clarification and flesh this out. So I apologize, Ms. McLaughlin. We will take this back another time.
Well, can I just ask that the specific questions be forwarded to Mr. Collins so that that the next opportunity to discuss it, we have those answers so that the opportunity to move forward is made available.
All right, thank you. That's a very legitimate request, and I'd request that everybody review the bill, get your questions to Mr. Collins, and thank you. I need to adjourn.
Motion.
Thank you. Is there a second?
Second.
Thank you. All in favor?
aye.
Aye.
Aye. Again, sorry, Ms. McLaughlin, and we'll hope to get this moving forward